Welcome back to the Courtroom Breakdown series. Today's case centers on Freddy Gonzalez, a 30-year-old defendant facing a mountain of charges, everything from evading arrest in a vehicle to theft, forgery, and unauthorized use. But here's the twist. Instead of one case, Freddy is tangled in multiple criminal files, all overlapping, all demanding answers. And despite the weight of these charges, the state and defense have struck a plea deal involving probation, restitution, and community service. Will the judge buy it, or will Freddy's past come back to crush this agreement? Stick around, because the clash between Freddy's financial struggles, flashy lifestyle, and the court's demand for accountability makes this one of the most dramatic hearings yet.
012008, State versus Freddy Gonzalez. Can I have the parties announced?
Christopher Ramos and Paul Savero for the defense.
All right. So in this cause number, counsels, have you received all discovery? Did you review it with your client?
We did.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand your attorney and you have certain rights? You have a right to have a grand jury hear the evidence in this case and make a decision on whether or not there's sufficient evidence to hold you over for a jury trial. Your attorney also has certain rights. They have 2 days where they're entitled to 2 days to pass upon presentation of the information to them, and also 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering into this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand that?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented?
We are.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Let's pause here. Freddy is charged with evading arrest with a vehicle, a third-degree felony in Texas. That means a possible 2 to 10 years in prison and up to a $10,000 fine. But notice what is happening. Instead of immediately locking him up, the state is offering community supervision with conditions like restitution, counseling, and random drug tests. Why? Because plea bargains are often the court's way of saving time and money, while still holding a defendant accountable. But here is the key question. Does offering 10 years of probation instead of prison make sense in a case where multiple crimes are stacked together? Asterisk, asterisk.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Anyone promised you anything other than the plea?
Yes, Your Honor. Or no.
Has anyone promised you anything other than this plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented? Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. The state recommends community supervision. This is run concurrent with 2025 CR 005706. I'm sorry. It's 2025 CR 005206. 2025 CR 007487, 2025 CR 007397, 2025 CR 009295. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
That is right.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be a TAP evaluation, 150 hours community service restitution, and in the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offense as charged, how do you plead?
No contest.
State, any evidence?
State offers into evidence states exhibit 1 with its
No objection.
All right, did you review the waiver and consent to stipulation and testimony with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge. We ask for it to be mindful that he's gainfully employed right now. This plea is a part of a larger plea that took place 2 weeks ago. The court asked us to return to provide some restitution. And the court also asked the state to provide documentation of restitution amounts. At this moment in time, I don't think that the state has been able to verify the various restitution amounts. But our client does have a significant amount of money to provide in terms of restitution once the state's able to verify those amounts.
We have tried vehemently, Your Honor, to get restitution amounts from all of our different victims. Some have said that they have restitution and will get us the documentation. They just haven't been able to locate it or provide it to us yet. Some have said they don't have any restitution, and there are a couple that we have not been able to get in touch with.
All right, so in this cause number, the 2025 CR 012008, restitution?
On this evading in a vehicle, no, Your Honor.
All right, what about the vehicle? Because it says that the vehicle was damaged with a screwdriver.
Oh, I'm sorry, Your Honor. This one is related to another case. Yes. That is one of the people that we reached out to, and they have not given us any documentation.
All right, how old are you?
30.
You're 30. And this happened on or about May 7th, 2025. Explain this to me. Why are you?
This is the judge's boiling point. Freddie is not just in court for one bad choice. He is linked to a string of thefts, forgeries, and vehicle crimes all happening within a short window. And yet the defense argues that financial hardship drove his actions, framing him as unsophisticated and desperate. But then comes the twist. The judge points out Freddie's designer Louis Vuitton belt worth hundreds of dollars. That contradiction cuts straight through the defense's hardship argument. Viewers, what do you think? Can someone claim financial struggle while flashing luxury brands in court, or does that kill his credibility instantly? Asterisk, asterisk.
Honestly, I don't even know why I should accept this agreement you've reached, because you're picking up evadings, forgeries, thefts, unauthorized use of a vehicle, another theft, manufacturing cases, and unauthorized use. So why should I follow any of these plea bargaining agreements?
I can offer the following, Judge. All of these cases deal, for the most part, dealing with financial or property crimes. At the time that he was committing these crimes, he was experiencing significant financial hardship. Well, that is not an excuse. If you have, not to be harsh, but if you have any sort of discussion with him, he not a very sophisticated individual. And I think as he's described, he took it upon himself to steal this property, sell it for funds, but he didn't realize how he was going to get caught. He thought this was too easy. So he continued, and if you look at the time frame of all of these offenses, they took place within a short matter of time. That's when the offenses caught up with him. He's a very unsophisticated individual. He thought he could get away with this. He was caught. I think even one of the offenses had a GPS tracker on them. He just did not think this through, because I think part of me thinks that he is, not to be harsh, but unable to think this through.
But he's able enough to get a Louis Vuitton belt. A regular leather belt you can get is $20, and you put the LV on it. That leather belt goes up to, I think, a minimum of $350. So he's sophisticated enough to do that. Unless it's a knockoff, and it doesn't appear to be a knockoff to the court based upon my experience.
Did you catch that the judge confidently declares, "Oh no, that is a Louis Vuitton belt"? This moment is more than a fashion critique. It is courtroom strategy. The belt becomes Exhibit A for the prosecution's main theme. Freddie knew how to hustle, spend, and flaunt even while claiming poverty. Judges often focus on these small details to measure credibility, and here adds a sting of humor in an otherwise serious proceeding. Imagine trying to argue financial desperation while the court zeroes in on your $350 belt. Do you think the judge was being petty, or was this a fair call out of hypocrisy? Asterisk, asterisk.
I honestly wouldn't know how to tell a knockoff from an authentic Louis Vuitton.
Oh no, that's a Louis Vuitton belt.
Is it?
So you want to, yeah,
But
I can spot the knockoffs.
And as the court inquires with him, you'll see that he just is incredibly unsophisticated in terms of being articulate, thinking things through, thinking that he could get away with it. So at the end of the day, he does have significant amount of, I consider significant, to pay the restitution off to these individuals if they can verify the amount. And if this restitution can be made whole to these individuals, it could be to their benefit as well.
All right, and what's the amount of restitution he's here with today?
He has informed us he's in position to provide $5,000 in restitution. All that we ask is that those amounts be verified by the complainants.
He probably could have had 6,000 if he wouldn't have had the Louis Vuitton belt.
Judge, that point, if I may, I know Chris has been, if I may, Your Honor, one of the ways he was able to raise the money was selling things that were near and dear to him. One of the items that he sold, ironically, was his vehicle. So as we speak right now, he is vehicleless, which is kind of ironic considering the charges that he has.
Ironic, but understandable.
And he did liquidate items that he could sell, and he was able to raise $5,000. That doesn't mean he's stopping. He's still trying to sell stuff. And for all I know, maybe the belt is one of the things he's trying to sell. But he has been liquidating his assets. Back to the earlier question. At one point, through hard labor and diligent work, he was able at one point to afford a nice living. He was working in the aggregate business, which is basically shoveling gravel and dirt and so forth. And at one point he was able to make a decent living. And then I don't know if you can notice he has been having problems with an arm of his that is the result of a birth injury that has been progressively getting worse with his age. And his means of earning that living kind of caught up to him with his disability. Prior to this, he's 30 years old. He has no criminal history. He thought he was going to be able to do something, and he just was not able to. He caught up with it, got caught. And do I feel like he's remorseful? I feel that way. Of course, it's not me experiencing his feelings, but I do. He has expressed regret. For all we know, maybe the regret is because he got caught. But he does express regret. He is trying to show some redeeming value. He has a young child that is about maybe 4 or 5 months old. How old is your child? 4 months. 4 months old. He's never been on any.
Now the defense pivots hard. Freddie is shown not as a criminal mastermind, but as a struggling young father with a newborn at home, trying to provide for his wife and baby. They highlight his past hard labor job, his disability, and his efforts to raise restitution by selling personal belongings, even his car. It is a strong emotional appeal, a man at rock bottom portrayed as remorseful and redeemable. But here is the question: should family responsibilities earn him leniency? Or does the court need to prioritize public safety over personal hardship? Where would you draw the line? Asterisk, asterisk, asterisk.
All right, this is what the court is going to do. In 2025 CR 012008, court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. This is to run concurrently with 2025 CR 005206, 2025 CR 007489, 2025 CR 007397, 2025 CR 009295. There's to be field visits one time per month for 6 months. There's to be 150 hours of community service restitution. 50 of those hours will be deemed satisfied upon completion of parenting classes. And there's to be, and you say you're currently not driving, you don't have a vehicle?
Yeah.
All right, there's to be no driving without prior court approval.
Judge, may I, just for future reference, the truck that they are working on to deliver aggregate, will you reconsider once that truck is prepared? So
Mhm.
Thank you.
And there's to be 10 days in the Bear County Jail as a condition of probation, and that will begin on, and you'll need to turn yourself into the jail. Deputy Mejia, do y'all want him to turn himself into the jail or turn himself in here?
The jail is easier.
All right, so, and you're gonna need to turn yourself into the jail no later than October 10th. Oh, October 10th? Yes. No later than 5 p.m. Did you review the document in that case entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. In 2025 CR 007487, the court previously found you guilty The court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's $1,000 fine that will be probated. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, and 012008. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Field visits one time per month for 6 months. 250 hours of community service restitution. 100 hours will be deemed satisfied upon completion of the MRT, which is being required. The remaining 150 will be deemed satisfied once he completes the anti-theft course. And there's to be no driving without prior court approval. And 10 days in the Bear County Jail as a condition of probation, beginning October 10th by 5 p.m. And you'll need to turn yourself in the jail by 5 p.m. on that date. And that cause number, did you review the document? And oh, I'm so sorry. Also, the state is taking in consideration 2025 CR 007488, 007406, and 009170. And Norma, in each of those cause number, I'm going to need a reset date in 30 days for restitution. All right, in that case, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Again, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes, sir.
And cause number 2025-005260. The court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits one time per month for 6 months, no driving without prior court approval, $10 days in the Bear County Jail as a condition of probation. You're to turn yourself in no later than October 10th. I'm sorry, you're to turn yourself in on October 10th by 5 p.m. There's to be 250 hours of community service restitution. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, 012008. Take in consideration 2025 CR 007488, 007406, 009170. Yes. Yes. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. We're moving on to 2025 CR 005205. And that cause number, punishment is to be assessed at 2 years in the state jail facility, suspended and probated for 5 years. There's $1,000 fine. This will run concurrent with 2025 CR 007396. There is to be restitution of $500 to Elizabeth.
This is classic judicial tough love. The judge tells Freddie flat out that financial hardship is no excuse for a crime spree. If everyone responded to life's struggles with theft and fraud, society would collapse into chaos, a world of Mad Max, as the judge puts it. This moment is key because it shifts Freddie's case from a personal sob story into a public policy warning. The court is reminding everyone that probation is a privilege, not a right, and it comes with expectations. Do you agree with the judge's zero-tolerance stance? Or do you think Freddie's situation deserved more compassion? Asterisk, asterisk, asterisk.
Mascaro. There's to be no contact with Elizabeth Mascaro. And with regards to that complainant, does he have a money order for $500?
You have
Yeah,
cash?
yeah, I have to.
No, not cash. They don't.
He doesn't have a money order, but
Do y'all accept cash?
I don't think they do.
All right.
Let's go get one, bring it back.
So you'll need to have a money order, bring it back tomorrow. Either your attorneys can bring it tomorrow. A money order for $500 made out to Elizabeth Mascaro, and you're to turn it in to the DA's office.
And which case number is that, Your Honor?
That's 2025 CR 005205. There's to be 100 hours of community service restitution, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no driving without prior approval from the court. There's to be 10 days in the Bexar County Jail. You to turn yourself into the jail on October 10th by 5 p.m. And there's to be field visits one time per month for 6 months.
Judge, for clarity,
Mhm.
what is the name of the $500 check?
According to your agreement, it's Elizabeth Mascaro, Mascorro. Did you review the trial court certification of defendant's rights to appeal in that cause number with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak with an attorney. And cause number 2025 CR 007937. Court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no driving without prior court approval, there's a $1,000 fine. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, 012008. State will take in consideration 2025 CR 007488, 007406, 009170. There's to be no contact and restitution to Adam Vasquez. There's 10 days in the Bear County Jail as a condition of probation. You to turn yourself in on October 10th, no later than 5 p.m. And there's to be 150 hours community service restitution. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And Norma, if you could start working on the reset form for him. All right, cause number 2025 CR 009295. Court is going to sentence you to 10 years in the prison, suspended and probated for 10 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, field visits 1 time per month until further notice. This is to run concurrent with 2025 CR 005205, 007396, 005206, 007487, 007397, taking consideration 2025 CR 007488, 007406, 009170. There's to be no driving without court approval. 150 hours of community service restitution. 10 days in the Bear County Jail. As a condition of probation, you to turn yourself into the jail on October 10th by 5 p.m. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In 2025 CR 007396, court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's $1,000 fine. This will run concurrent with 2025 CR 005205. There's to be restitution to Mark Crofton, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, field visits 1 time per month for 6 months, 10 days in the Bear County Jail. As a condition of probation, you to turn yourself into the jail on October 10th, 2025 by 5 p.m. There's to be no contact with Mark Crofton, and there's to be 100 hours of community service restitution. Probation in any of those cases, is there any other condition that is needed?
Get it open 1 other month until further notice, but on all the other ones, first month,
Yes.
no.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes, Your Honor.
and sign it?
Yes, Your Honor.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, Ms. Ferguson, what date for restitution hearing? All right, so we're going to be back here on October 30th for restitution hearings. Make sure that when you come back on that date, that you have money orders.
May I approach, Your Honor?
Yes. All right, we can go off the record. Here's the thing. You're old enough now in your life to know better and do better. And there is no excuses for your behavior. You understand?
Yes, sir.
If everybody who had some sort of issue where they lost their job or something didn't go their way, if they decided, you know what, I'm just going to throw my hands up and I'm going to start committing crimes, then where will we be? We will be in the world of Mad Max, and this is the United States, and you're not allowed to do that. Do you understand?
Yes, Your Honor.
So from here out, everything you do, you need to ask yourself if this could result in your being placed in prison for up to 10 years or up to state jail facility for 2 years. If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand? All right, good luck to you.
Thank you, Judge.
You're welcome.
Appreciate your time.
Thank you.
And that is the outcome. Despite multiple charges, Freddy Gonzalez avoids a long prison term and instead gets 10 years of probation, community service, restitution payments, and strict limits on his life. The court even added a symbolic punishment, 10 days in jail, to drive the point home. This case shows the balancing act judges face, protecting the community while still giving defendants a chance at rehabilitation. Freddy walks out with one last warning: no excuses, no shortcuts, and no more Louis Vuitton belts in court. If you found this case as fascinating as we did, hit that like button, share your thoughts in the comments. Was this sentence too soft, too harsh, or just right? And do not forget to subscribe for more jaw-dropping courtroom breakdowns. Asterisk, asterisk, asterisk.